I want to thank you all for being here today. And before we do get started, I would like to introduce or announce that we have our Cherokee Nation delegate to Congress in the audience today, Kimberly Teehee. And we also have our Deputy Secretary of State, Kanan Duncan. Thank you both for being here. This month commemorates the 185th anniversary of the signing of the 1839 Act of Union, an act that unified two branches of the Cherokee people into a single Cherokee Nation government. Today, we are first going to hear from Cherokee historian Jack Baker about this historic meeting in 1839, and after we will hear from Chrissi Nimmo, who is a Vice President Associate General Counsel for Cultural and Economic Development, and also a former Deputy Attorney General of the Cherokee Nation, and she's going to discuss what this means for us today legally. Before we get started, we do have a video from Chief Ploskin. He apologizes that he can't be here today, but he did record a video for us to show at the beginning of this, and so we are going to start with this.
OCO, July 12th is one of the most important days of celebration for Cherokee Nation. In 1839, the Cherokee people were bitterly split. The brutal federal Indian policy that ultimately led to our forced removal generated distrust, division, and even political violence. Prior to the Trail of Tears, a group of early immigrants from our original homeland, known as the Old Settlers, had established a new government headquarters near present-day Gore. The Trail of Tears occurred on the heels of another great split. Cherokee Nation's government, led by Chief John Ross, opposed a removal treaty. Meanwhile, a minority faction led by Major Ridge supported removal. Ultimately, the Treaty of New Echota, signed by the Ridge Party, triggered our forced removal in 1838. After removal, violence ensued between the Ross and Ridge factions. The young government established by the Old Settlers seemed entrenched. It surely appeared to many of our ancestors that what divided us might get the best of us and keep us separated forever. But that's not what happened. Instead, the Old Settler government eventually agreed to dissolve, and Cherokee Nation continued on as one government for one united people. It took real leadership, courage, and statesmanship to craft what became known as the Act of Union. On July the 12th, 1839, we committed to heal divisions and work towards a new Constitution. Leaders like John Ross, William Cootie, George Lowry, John Looney, Jesse Bushyhead, Sequoyah, and others helped inspire and encourage Cherokees to set aside what had nearly torn us apart forever and instead focus on our common history and our common future. A few months later, our new Constitution was ratified. We celebrate that event as the Cherokee National Holiday. Our troubles wouldn't exactly vanish overnight, even with the Act of Union and our new Constitution. Our ancestors revisited the issue in 1846, finally putting any lingering disagreements to rest. But that enduring sense of unity would not have been possible without the 1839 Act of Union. Cherokee Nation, the same Cherokee Nation that existed before the founding of the United States, the same Cherokee Nation that is party to every treaty approved on behalf of the Cherokee people, would continue on as a single government. That government has continued uninterrupted to this day. We are the government with exclusive jurisdiction over the Cherokee Nation Reservation and the exclusive party to all Cherokee treaties with the United States. Each July 12th, we celebrate the Act of Union to honor our ancestors' courage and their ability to put the interest of all of our people ahead of those things that may separate us. Frankly, we also celebrate the Act of Union to set the record straight from time to time. Unfortunately, some people buy into the nonsense that Cherokee Nation remains split after removal, or that we even cease to exist at different times in history. Some people even confuse the creation of the Eastern Band of Cherokee Indians decades after the Act of Union and the creation of the United Kituah Band of Indians in Oklahoma by Congress in 1950 as evidence of some sort of enduring split. The creation of those bands of Cherokees are important points in history, but that has nothing to do with the divisions healed by the Act of Union or the uninterrupted existence of the Cherokee Nation. The 1839 Act of Union, along with our Constitution and our treaties, binds Cherokee Nation to its past and its future. So let's celebrate the Act of Union and remind the world that Cherokee Nation healed up our divisions nearly 2 centuries ago, that we never went away, and that we have a sense of duty to each other. We celebrate because we are still here as one nation.
It's a great video. And that video is available on Visit Cherokee Nation's YouTube if you're interested in watching that again. All right, our first speaker today will be Jack Baker. He is a former Cherokee Nation tribal counselor, president of the Trail of Tears Association, and also board of directors for the Oklahoma Historical Society. So everybody please give a warm welcome for Jack Baker.
Good afternoon. It's good to see everyone. So our Cherokee Nation is now in northeastern Oklahoma. But how did this become the Cherokee Nation? Our original lands were in the southeastern part of the United States. And following the Revolutionary War, several of our Cherokees who had sided with the British moved west of the Mississippi to Spanish territory, eventually residing in west central Arkansas. And with the cession of a large amount of land in the east by the treaties of 1817 and 1819, which included most of our ancient towns, including Catahlequah and Shota, our lands were reduced by 90%. These 1817 and 1819 cessions, however, also granted the Cherokee Nation title to the lands in Arkansas, where about 1,000 of our people were living. So the small part that shows in Arkansas were the lands that we received. So these Arkansas lands were then traded by the 1828 treaty for lands that is now our jurisdictional area in present northeastern Oklahoma, which is the pink area of the map there. The Arkansas Cherokees, who became known as the Old Settler Cherokees, then moved en masse in the summer of 1829 from Arkansas to our present nation. And by the Treaty of 1835, the remainder of our lands in the east was ceded by that fraudulent treaty. While the majority of the Cherokee Nation were opposed to the treaty, it nevertheless was implemented in 1838, with the vast majority of our people being forced from their homes and into camps for removal. And while they were in these camps in the east, at a general council of the Cherokee people, a resolution was passed on August 1st, 1838. Part of the resolution states, "And whereas the Cherokee people have existed as a distinct national community in the possession and exercise of the appropriate and essential attributes of sovereignty for a period extending into antiquity beyond the dates and records in memory of man. Resolved, therefore, by the National Committee and Council and people of the Cherokee Nation and General Council assembled, that the inherent sovereignty of the Cherokee Nation, together with the Constitution, laws, and usages of the same, are, and by the authority aforesaid, are hereby declared to be in full force and virtue, and shall continue so to be in perpetuity." And this resolution became of prime importance once it arrived in the West, where the old settlers were operating under their own form of government. It provided that the government of the newly immigrated Cherokees, who became known as the immigrant Cherokees, was in full force and effect as it had been in the East. So we now had two governments operating in the Cherokee Nation. So this problem had to be resolved by the two groups of Cherokee. While the nation's government had to be rebuilt, the immigrant Cherokees had to rebuild their homes and farms. After the old settlers' removal from Arkansas, they settled primarily along the principal waterways, with the majority of them along the Arkansas and the Grand Rivers. And many of the treaty party had arrived a couple of years before and had also settled along the various streams. And much of the land, however, was still vacant. 3 of the Moravian missionaries to the Cherokees had been in camps with the Cherokees in the summer of 1838 and decided to remove ahead of the majority of the Cherokees. Some of their church members had immigrated in early 1838. So the Moravians arrived here in late October of 1838, and they give several accounts of the land before the majority of the Cherokees had arrived. And these descriptions have recently been translated from the archaic German script in which they were written. Their first night in the nation was spent at Widow Weber's plantation, which is at present Stillwell. They then came to Park Hill and stayed with Elias Budnot, who had been one of their pupils in the East. And he was living about a mile south of Hunter's home. A side note, the Moravians sent a map back to Salem as identified in a letter of the 4th of April, 1841. It's a letter from Miles Vogler of Beatty's Prairie to the Reverend Theodore Schultz of Salem. That's Salem, North Carolina. Brother Herman and myself have drawn a very imperfect sketch of the country, the object of which is merely to show you how our people are situated and in what directions Spring Creek is from this place. At that time, they were living at their mission site, which was about 4 or 5 miles south of Southwest City, Maysville, Arkansas. It says, you will find it in the enclosed sheet and regard it only intolerable correct as respects the situation of our scattered church members. And this is likely the earliest map of the Cherokee Nation West, and I'll use excerpts of it in a couple of places in the presentation. 30th of October, 1838, we drove with Elias Budnot to Young Wolf's, who lives 5 miles from Park Hill. You can see Park Hill there, and then up above is Young Wolf, who actually lived just across the creek up on the bluff here. And he was a Methodist, was a Methodist preacher, and he had worked with the Moravians in the East before he immigrated in 1834. So they were good friends of Young Wolf. And Young Wolf later gave his improvements for the town of Tahlequah to be built. Young Wolf, at whose home we arrived after a drive of 2 hours, we were received with much joy and given hospitality. He treated us to very pretty and delicious honey, which is to be found in plenty in the woodlands here in the land. He himself, however, has also taken up beekeeping. After we had eaten at noon, he drove with us into the region about 8 miles from his house, where our brothers and sisters have been living for the time being, and that's west of Tahlequah on 14 Mile Creek near present Hulbert. So in the past week, however, since he had gotten sick from fever there, they have moved to another region 14 miles from there on the Barren Fork of the Illinois River, which is at present Proctor. Another reason they did not want to settle here was that it has been so hard for them to haul their provisions, which for now they have to buy so far from the settlement. They also didn't like the nearness of the prairies, where their cattle wandered so far afield, and several of their cattle and horses were torn apart by wolves, which were there in large packs. And there were also outbreaks of smallpox in the region, which the Indians are so afraid of and which have taken away whole nations of them. 31st of October, Brother Ruda rode with Elias Budnot to Park Hill to dispatch a letter to Salem to our correspondent, Brother Schultz. Brother Vogler visited Brother Austin Copeland, who lives 3 miles from here. He had built a new house and mill for himself on the prairie, and also working his profession as a blacksmith. And Brother Smith, in the meantime, had a conversation with our old friend Young Wolf, who showed him around on his sizable farm, which is where we are now, which has excellent land. This year, in spite of the dry weather, he got an abundance of Welsh corn. From 1 bushel and 1 peck of wheat which he planted, he harvested 52 bushels. And also, he had lost several pigs to the wolves. And 5th of November, after a heartfelt departure from Young Wolf and his family, who had shown us such friendship, we traveled to the Barren Fork of the Illinois, some 13 miles from there, where our brothers and sisters have settled and formed a settlement scattered over 8 to 10 miles. So we began our journey to Honey Creek on the north side of the Cherokee Territory, where it borders the land of the Senecas. We went there to visit our 2 Cherokee sisters, Susanna Ridge and Susanna Fields, and others of our old acquaintances. So Major Ridge's wife, Susanna, was a member in the Moravian Church. We traveled along the various arms of the Illinois River through thick forest land, and then again through prairies, of which the largest is known under the name of Beatty's Prairie, and in which the parched grass is strikingly in full flames, so that only the road which leads through this was open. It was a horribly beautiful and magnificent sight. Although the weather was very frigid, we were not too cold since the fire and smoke warmed us a little. We found the land everywhere of the first quality. There are only a few settlements to be met with on the whole 70 miles on the road from Park Hill. Here and there are a few where the Cherokee immigrants who moved here in the spring have settled. We saw them very busily building houses and clearing land. These regions a short time ago were the halting place of the Osage, who in the whole have moved out of the area. Nevertheless, from time to time, we see some who move into the land around here. There are also some villages of the Delaware Indians who hunt all over the Cherokee land and on a friendly footing with them. 30th of November, the Cherokees here are in civilized parts, and just as much as those in the east, have nice farms, well-built houses, and raise beef cattle, horses, and pigs in quantity. Stan Wadey and his father, Brother Christian David Wadey, who lives across the river from Park Hill and down below a little bit, they have harvested so much corn this year that in addition to what they need for their own use, they still could sell 1,000 and some bushels at $1.50 a bushel. The climate here is similar to that in Georgia and Tennessee, only that the winters here are uncommonly stronger. In the months of July and August, fever is generally prevalent in these parts, and on the whole, is not as healthy here as it is east of the Mississippi. In the forests here, one encounters a great diversity of trees, among which several are the usual thickness and height, walnuts and oaks of various sorts, hickory, maple, poplars, or tulip tree locusts, water beeches, and many other types of wood. Chestnuts are not to be found here, and was one of our primary food sources in the east, and we lost that with removal. One finds some pines and cedars only in the mountains, and they are rare on the whole. And then he wrote in the margin, cane or reeds, which are an excellent fodder for the animals, grow especially in the low places near the rivers. Here in our region, they are rather plentiful. 10th of January, and by this time the Ravens had purchased an improvement on the Barren Fort near present Proctor. It was actually right across the river from Camp Egan. Brother Vogler went on business to the smithy 8 miles from here, and in several areas here in the land bituminous coal is found, and iron and copper as well. Limestone is also in abundance. And the road from Washington County, Arkansas, to Fort Gibson goes right by our houses. Therefore, every day travelers and freight wagons pass by here. And since the road is bad in places, in many areas is very mountainous, it is not unusual to see wagons pulled by 6 yoke of oxen. These animals are referred here to horses for all work, especially for breaking up the grasslands on the prairies, which can often require 2 yoke of oxen to 1 plow. But once this is done and the ground has been cultivated for a year, the earth becomes as soft as the ash heap. The Cherokees have some very productive salt works here, and there will be a sizable business carried on with this article in the neighboring states. The salt here is strong and comes in granules, but is not as white as our usual kitchen salt. It's said to be especially good for curing meat. 24th of March, 1839. In the last week, the last detachments of Cherokees have finally arrived, so that now the immigration, which began on 1st of September of last year, has now reached its end, and the 15 or 16,000 Cherokees are now their new homeland here in the West. Then he writes in the margin, the entire Cherokee Nation, including those who are already living here in the West, now amounts to about 23,000 souls. May God grant that they may possess the land a right long time, and that they may become a prosperous and happy people here, and that many of them may be blessed not only temporally but also eternally. 1st of April. During this past winter, our Indians were busy getting land ready to sow with Welsh corn, and it's getting time for planting now. Not too much can be done with cultivating the corn this year. However, since they're still busy with building their houses and other work, and most of them are still getting sick with fever from time to time, so thus the people began to rebuild their homes and farms. But the two governments also worked to build the government into one. On April 23rd, 1839, Chief John Ross wrote to the three chiefs of the old settlers, John Brown, John Rogers, and John Looney. Ross suggested that a joint council be held to discuss what kind of governmental structure was needed to reunite the Cherokee people. He wrote, "We are all of the household of the Cherokee family and of one blood. Therefore, together, we should take measures for cementing our reunion as a nation by establishing the basis of a government." The old settler chiefs agreed to meet, and on June 3rd, 1839, over 6,000 Cherokees assembled at the Tahlequah campgrounds, which is about 4 miles northeast of here, on Double Springs. John Brown, principal chief of the old settlers, addressed the gathering. "We joyfully welcome you to our country. The whole land is before you. You may freely go wherever you choose and select any place for settlements which you may please. You are eligible to any of the offices. Next July will be an election for members of both houses of our legislature. At those elections, you will be voters. Meanwhile, it is expected you will be subject to our government and laws." And for the immigrant Cherokees, this was very problematic, because Brown spoke of the area as our country, which implied that the new immigrants were being admitted as a privilege and not as a right. More disturbing was the implication that the new arrivals had no government of their own and would submit to the government of the old settlers. This was in direct opposition to the resolution passed in the East on August 1st of 1838. It also meant that the majority of the Cherokees would be governed by the minority. So on June 10th, John Ross explained to John Brown and the other leaders of the old settlers that they could not accept their terms. Brown responded that for all matters growing out of removal, the immigrant Cherokees would be allowed their own chiefs and committee and council, with the name being the Eastern Cherokee Nation. Brown proposed that there be two governments in the same territory. On June 20th, the council at Tahlequah was declared by the old settler chiefs to be over without there being a resolution to the problem of the two governments. Before everyone had left, however, two Cherokees, whose fame and popularity transcended party lines, Sequoyah and Jess Bushyhead, called upon the people to meet again on July 1st to reunite the Cherokee Nation. On June 22nd, principal leaders of the Treaty Party, Major Ridge, and then John Ridge and Elias Boudinot, were all executed for their role in signing the 1835 treaty. Despite this, the council called for by Bushyhead and Sequoyah and convened at Illinois Campground, which is a couple of miles north of Park Hill. It's actually where the bypass goes around and crosses the Tahlequah Branch, as I call it. It's between there and the river. But only about 2,000 Cherokees attended, with probably less than 150 of them being old settlers. The only old settler chief to attend was John Looney. An act of union was approved and signed on July 12th by the immigrant Cherokees, but the old settlers had not yet agreed to it. The Moravians gave the following accounts in their journal. Sunday, 28th of July, 1839. Mr. Bushyhead called on us on his way home from the council. The hope for a brotherly agreement among the various parties of the nation seems to be better now. However, everything is still very uncertain, and for our part, we can only watch in stillness and patience and diligently beg the Lord for help for this poor, disowned, and disinherited people. The 19th of August, in the evening, Dr. Butler, as a side note, Dr. Eliza Butler never gets his due place in Cherokee history. because he, along with Samuel Wooster, were imprisoned in the court case of Wooster. There was also one, Eliza Butler was part of that, so that he was imprisoned the same. And then after removal, he and his wife were the first first directors as a female seminary. And so he worked for the Cherokee Nation for several years after that, but I digress. Okay. But in the evening, Dr. Butler and Brother George Hicks came to visit us. From the latter, we received the news that the long-awaited unification of the parties in the nation is about to be realized. So the old settlers agreed to the Act of Union and signed it on August 23rd of 1839. And part of this Act of Union states, whereas our fathers have existed as a separate and distinct nation in the possession and exercise of the essential and appropriate attributes of sovereignty from a period extending into antiquity beyond the records and memory of man, and whereas these attributes, with the rights and franchises which they involve, remain still in full force and virtue, as do also the national and social relations of the Cherokee people to each other and to the body politic, excepting in those particulars which have grown out of the provisions of the treaties of 1817 and 1819 between the United States and the Cherokee Nation, under which a portion of our people removed to this country and became a separate community. But the force of the circumstances have recently compelled the body of the Eastern Cherokees to remove to this country, thus bringing together again the two branches of the ancient Cherokee family. It has become essential to the general welfare that a union should be formed and a system of government matured, adapted to their present condition, and providing equally for the protection of each individual and the enjoyment of all his rights. Therefore, the people composing the Eastern and Western Cherokee Nation and National Convention assemble, by virtue of our original and unalienable rights, do hereby solemnly and mutually agree to form ourselves into one body politic under the style and title of the Cherokee Nation. So here are the signers of the Act of Union. If you note that it tells up above that it's the 12th of July, 1839, and then we have the Eastern Cherokees who sign it, with John Ross as the principal chief. But then we have the Western Cherokees, and then they approved it on the 23rd of August, 1839. So it has the signers there, and then it says the foregoing instrument was read, considered, and approved by us the 23rd day of August, 1839. Then it goes, Aaron Price, Major Pullum, young elders, etc. And then it says, and a great number of respectable old settlers and late immigrants, too numerous to be copied. So the Act of Union, as Chief Hoskins said, paved the way for the Constitutional Convention and the adoption of a new Constitution on September 6, 1839. And Raven missionary Miles Vogler gave the following account in a letter to Reverend Schultz in Salem, North Carolina. It was October 8, 1839. Dear brother, I'm very glad to inform you at this time that a kind of union has taken place between the old settlers and immigrants. I was at council on the fourth ultimate, at which time the new Constitution was laid before the convention by Mr. Ross. This convention consisted of 50 persons, and 25 were old settlers. And we did not know until we took this Moravian letter that it was evenly split, 25 old settlers and 25 immigrant Treaty Party Cherokees. And after the convention read the Constitution and made some necessary amendments, it was presented to the people, with whose approbation it met and consequently was adopted. After this, the people elected their officers. John Ross, of course, was appointed principal chief, Joseph Vann, second principal chief, and then he states not the one who formerly lived near Spring Place, because the Joseph Vann who lived near Spring Place was the rich Joe Vann that lived near Weber Falls, and this Joseph Vann was an old settler that lived just south of present Locust Grove. This is Major Lowry, Richard Taylor, and George Hicks refused to hold any offices. The members of the council and committee are mostly all strangers to me, and I suppose we to them. Then Mr. Ross's council will adjourn this week after a long and tedious session. Mr. Brown is trying to hold a council which was to commence this week, and I do not know who will attend, as the majority of the old settlers have united themselves with Mr. Ross. Perhaps some of the treaty party will join Brown, but if they do, it will amount to little. Jack Bell and Stan Wadey are going to Washington as the delegates of the treaty party. Signed, Miles Vogler. Here are the signers of the 1839 Constitution. So thus, our new Constitution was implemented and remained in place until 1975, when a new Constitution was passed by the people. Our nation was on its way to being rebuilt, and the blessing asked for by the Moravian missionary in April of 1839 has come to pass, where he stated, "May God grant that they may possess this land a right long time, and that they may become a prosperous and happy people here," which we have done. Thank you.
All right, that was a great presentation, Jack. Thank you for that. Our next presenter is Chrissi Nimmo. She's VP Associate Counsel or General Counsel for Cultural and Economic Development for Cherokee Nation businesses. And she's also the former Deputy Attorney General of the Cherokee Nation. So everybody, please give a warm welcome for Chrissi Nimmo.
I'm going to talk a little bit about what happened after the Act of Union and why some of those things are still really important to us today. A little bit of detail of some of the things that Chief mentioned. I do find it interesting. Jack read part of the Act of Union, and Jack was talking about it from a historical perspective. I was looking at it from a legal perspective, and I pulled out the part to read to you that Jack didn't read. So this is the only thing I'm going to actually read you, and it's pretty short, but this is from the Act of Union. All rights and titles to the public Cherokee lands on the east or west of the river Mississippi, with all other public interests which may be vested in either branch of Cherokee family, whether inherited from our fathers or derived from any other source, shall henceforth vest entirely and unimpaired in the Cherokee Nation as constituted by this union. So the Act of Union legally said whatever these different groups owned, had claim to separately, it is all back under one Cherokee Nation. So going forward, what did that mean? You did hear Chief say in his video that our troubles didn't vanish. So what was really interesting about the Act of Union, and it was wholly within the Cherokee people. There was not an outside entity telling us that we had to do this. There was not anyone drafting us for us. There wasn't anything being forced upon us or offered in exchange for something else. This was purely the Cherokee people coming together and saying, this is what we're going to do. But as we heard, it didn't solve all of our problems. During the Treaty of 1846, which was between the United States and the Cherokee Nation, there was specifically language put in that treaty, and this was the last time kind of that this language was used in treaties, where the Cherokee Nation that was entering a treaty with the United States government agreed that all difficulties and differences heretofore existing between the several parties of the Cherokee Nation are hereby settled and adjusted. So this was the United States government asking the Cherokee Nation that had come together under the Act of Union to agree in the treaty that all of these issues were settled, that there was one Cherokee Nation government, there were one set of laws, there were one constitution. And we agreed to that in the 1846 treaty. What is important about that is there were a few more treaties following that made with the Cherokee Nation, the same Cherokee Nation that was party to the 1846 treaty. The most important of those being the Treaty of 1866. And I just want to talk a little bit about some of the important parts of the 1866 treaty. One thing that it did that was very important was it reaffirmed all previous treaties with the United States government that were not in conflict with the 1866 treaty. There obviously were some parts of conflict because we were still ceding lands and those types of things, but any promises that the United States government had made to the Cherokee Nation in any of the other previous treaties, if there was not conflicting language in the 1866 treaty, it said those are still binding legal promises on behalf of the United States government. And why does that matter today? Well, it does because there are lots of provisions in that treaty that are current issues for the Cherokee Nation, one being freedmen citizenship. The 1866 treaty was where Cherokee Nation promised to admit freedmen and their descendants on the same legal footing as Native Cherokees. And that chapter of Cherokee Nation history has only recently finally come to a close, but that promise was made between Cherokee Nation and the United States government in the 1866 treaty. It also recognized Cherokee courts and continued Cherokee courts and gave exclusive jurisdiction to Cherokee courts over some matters, including civil matters that were purely between Cherokees. Those issues come up again in recent history in the McGirt proceedings and some of the arguments that the state of Oklahoma made there. And again, it reaffirmed all of those previous treaties. So rights that we still depend on today, such as providing for the health and welfare of citizens, which is where we get IHS, which is where we get tribal funding. Those promises that the United States made in the initial removal treaties were reaffirmed in the Treaty of 1846 and 1866, and we are still able to rely on those promises and those agreements today in modern Cherokee Nation. I want to talk a little bit about, Chief talked about that there are arguments or theories that the Cherokee Nation is split, that there are different groups who are treaty parties, and I want to talk about some of the court cases and congressional legislation that have recognized that the Cherokee Nation of today is the same Cherokee Nation of pre-removal of the 1846 treaty, of the 1866 treaty. And here are some of those cases. The Supreme Court in 1970 in the Arkansas Riverbed case found that the Cherokee Nation, along with the Chickasaw and Choctaw Nations, owned the riverbeds of the Arkansas River. And that was because when, by treaty, Cherokee Nation was granted what is the current modern-day reservation, when Oklahoma became a state, lands that belonged to the tribe that had not been allotted stayed with the tribe. And the argument in the court was when Cherokee Nation got fee patent, not our traditional reservation where the government set aside some land and still owned it and put Indians on it, but titled the land to the Cherokee Nation, the patent which we have in our archives. When the federal government titled this land to Cherokee Nation, were the lands under navigable waters included in that? The tribes argued yes, and because those lands weren't allotted, the tribe should still own them, not the state. The state argued no, the rivers weren't part of the land or reservations of the tribe. It was just the edge of the river. And the Supreme Court in 1970 said yes, holding fee patent title to land and rivers included in it, give that landowner the riverbed. And those are important cases for the Cherokee Nation. Choctaw and Chickasaw Nations still are today. There's Arkansas Riverbed Authority that meets quarterly at the Intertribal Council because people do things on the river that they need permission from the people who own the riverbed, including taking sand and gravel, including building across the river and getting easements to put highways or power lines. And those are all still modern day issues that for the portions of the river that reside within the Cherokee Nation, if someone wants to do something crossing that river, they have to have the permission of the Cherokee Nation to do it. This was an issue that came up a couple of years ago with power lines that were going to go through Sequoyah County into Arkansas, and Cherokee Nation did not give an easement, and therefore those lines could not cross the river. Again, very current modern day impacts of this. Following the Supreme Court case, so all the Supreme Court said was, yes, the tribes own the riverbed, but that didn't kind of settle some of the outstanding issues. And this worked its way through courts and appeals, political action for several years. But in 2002, the United States Congress passed the Arkansas Riverbed Settlement with the Cherokee, Choctaw, and Chickasaw Nations. And this is language that, as an attorney for the tribe, I cited often when we were writing briefs, but a congressional finding. So this was a law that was passed by Congress, and this was the language that was included. The Cherokee Nation, a federally recognized Indian tribe with its present tribal headquarters south of Tahlequah, Oklahoma, has maintained a continuous government-to-government relationship with the United States since the earliest days of the Union. So this, in 2002, was Congress recognizing and reaffirming that today's Cherokee Nation is the same Cherokee Nation that began in the eastern United States. And that is a federal law that says, yes, it is the same Cherokee Nation. It was never dissolved. It has had a continuous government-to-government relationships with the United States. There were other, as Chief mentioned in the video, there have been arguments that even that the Cherokee Nation ceased to exist at some point. And this is another issue that we have very modern legal answers to this question because, and I'm going to do a real quick aside here, the McGirt case, I think everyone kind of recognizes that name and knows what it is. It was about the state's criminal jurisdiction over Indians in Indian country. And when that case was working its way through the courts up to the United States Supreme Court, one of the arguments that the state of Oklahoma made was that the Curtis Act abolished the 5 tribes, that they ceased to exist and they somehow all later came into reformation or re-being under the Oklahoma Indian Welfare Act or some other way. And that argument was pushed by the state of Oklahoma. That was kind of what they were hanging their hat on in this McGirt case, that the Curtis Act abolished the tribes and abolished the tribal courts. Therefore, the reservations that they have could not have extended because they were abolished by Congress in the Curtis Act. And the United States Supreme Court in the McGirt case, and then which McGirt was Creek. So in the McGirt case, they found that the Curtis Act did not disestablish the reservation of the Creek Nation and did not abolish the Creek Nation. After that case, there was a Hogner case, which was a Cherokee Nation case in the Oklahoma Court of Criminal Appeals. And then there was a Castro Huerta case, which was also a United States Supreme Court about criminal jurisdiction over a non-Indian in Indian country. But the state, again, made these arguments as to Cherokee Nation, one of their arguments. Their other argument was that Oklahoma becoming a state abolished the reservations, and they didn't win on that one either. But this idea that federal laws leading to allotment, federal laws attempting to terminate, but unsuccessfully, tribal governments, or the formation of the state of Oklahoma, that any one of those things interrupted the continuous existence of the Cherokee Nation government, the United States Supreme Court has said no, that it did not. The tribes continued to exist, the reservations continued to exist, and again, those are modern day issues that we're dealing with. There are other issues from these treaties that if you read a newspaper, if you are on Facebook, you see issues come up that are still promises that were made to the Cherokee Nation by the United States government that we are dealing with in modern Cherokee history. The biggest one that has recently made the news are hunting and fishing rights. So tribes have hunting and fishing rights because of treaties. And we just saw the announcement that the 5 tribes entered into an agreement to allow their citizens to hunt and fish on the reservations of the other 5 tribes. We are able to do that because we were guaranteed those rights in treaties that are still enforceable today. Water rights are always ongoing issues with there being less of it and there being less clean of it. Taxation, there are cases working their way through state courts right now on the state's ability to tax Indians on Indian country. Again, these health and welfare provisions that were made that are the basis for a lot of federally funded tribal programs. And last but not least, delegate to Congress, which was a promise that was made in a treaty that was reaffirmed that is a modern day right that the Cherokee Nation is asserting. So those are just some of the reasons that what started with the Act of Union, because it could have led to something different, but what it led to was unifying and recognizing one Cherokee Nation, one treaty tribe. Just a couple of notes. As Chief mentioned, there are claims that there are other Cherokee tribes that have treaty rights. As far back as 1886, the United States Supreme Court recognized that the Eastern Band of Cherokee Indians did not have treaty rights because there were a group of the Eastern Band who remained in the Eastern United States who filed a court case in the Court of Claims claiming that they were entitled to some of the money that the Cherokee Nation, who was now in Indian Territory pre-state of Oklahoma, agreed to in treaties that they were going to be paid from the United States government. And the Eastern Band said, oh, we should get some of that money because we're all the Cherokee Nation. And the court said, no, you didn't go to the new seat of government. You did not relocate. You are not part of that tribe if you are not in that area and subject to the same promises and restrictions that that tribe is. The UKB, there's never been a court find that UKB was a treaty tribe or possessed any rights under the treaty. And oftentimes there is mentioned the Catawba Society Incorporation in 1905, which was prior to Oklahoma statehood. And there was in what was at the time Indian Territory federal courts. So this was before Oklahoma was a state. There was a federal court in Indian Territory. There were certain laws that applied to Indian territories, but it wasn't a wide range of laws. So via the Curtis Act, the United States government said in Indian Territory courts, in this area at least, they were different in different areas, the laws of Arkansas Digest are going to apply in Indian Territory because things were starting to happen. Like people were setting up towns and they were fighting with their neighbors over things. And there needed to be some law that allowed the federal Indian Territory courts to kind of adjudicate the everyday disputes of what was a growing community. So the Digest laws of Arkansas applied. The Catawba Society incorporated in 1905 under the laws of the Arkansas Digest for, and I quote, a corporation for benevolent purposes. So the incorporation of the Catawba Society was not some federal Indian law action. It wasn't federal recognition of a tribe. It wasn't them acting as a tribal government. It was them forming a business for benevolent purposes under the law, much like one of the other groups that incorporated under the law at the time were the Masons. So those are some of the arguments that are raised when there are arguments made that there are other Cherokee tribes who are treaty parties or who have treaty rights under the various treaties that were signed by the Cherokee Nation. And with that, I think I'm going to quit, and we might have a few minutes for questions. So I'm going to invite Catherine up. No. The one thing related to allotment that has changed in the last 10 years is the Stigler Act used to require that for allotment land to pass to family members and retain that restricted status, they had to be 1/2 or more Indian blood. And that restriction as to the 5 tribes was removed by federal law. And we don't have a lot of allotment land left. But now, so long as that person is a direct descendant, that land can go to them when their family member dies and stay in restricted status regardless of the blood quantum of the family members. And so it won't allow any land to return to restricted status, but it will allow us to reserve the restricted status of allotment land that exists today. I'm going to preface this with, I know what I've read about it, but I believe what it means is that if you have permission to be on the land, if it's private owned land and you have permission, or if it's public land and you're allowed to be there, for example, Lake Tenkiller, and you're a Cherokee citizen or a citizen of one of the other 4 or 5 tribes, that your tribal ID will work as a fishing license. I do know that the Cherokee Nation and the other tribes have put out kind of an FAQ addressing some of this because it's new, and I think all of that's on their website.
It was in 71 that we had our first election in current times, principal chief. But primarily, those chiefs of the day were to sign away land, such as our, say, railroad depots and different things that had reverted to the tribe and was being sold to someone else. So that was primarily what they did, because the BIA had sort of forced the untruth on us that there was no longer a Cherokee Nation. But as you said, the Oklahoma Enabling Act did state that the governments of the 5 tribes would stay in full force and effect, fortunately.